Wu versus Uber Technologies.
Good afternoon, Your Honors, and may it please the Court. My name is Joshua Kellner, and I represent Emily Wu. May I reserve 5 minutes for rebuttal, please?
Yes.
Your Honors, this case is about whether New York law contains any safeguards to protect consumers doing business on the Internet. Emily Wu clearly and explicitly chose the forum where she wanted her case against Uber to be litigated, the Supreme Court of the State of New York. And if Uber's attorneys had come to a preliminary conference in this case and asked Ms. Wu's counsel if she would agree to give up her right to trial by jury and go arbitrate in a forum of Uber's choosing, the answer we all know would have been no.
But what if they had chosen to enforce the 2016 arbitration agreement that she acknowledged when she got the car?
Well, as a number of courts around the country, including the Massachusetts Supreme Court in Cowders, the Maine Supreme Court in Maine, the Federal First Circuit, and even a court in New York before that time, have all held the 2016 terms didn't bring about legitimate contractual assent. And that's true for a couple of reasons.
But it seemed when I was reading your briefs at first that this was, as you were just describing it, all of a sudden Uber comes in and says, wow, too bad you signed this 2021 arbitration agreement, and I know that's what they put in their notice, but there is this 2016 agreement out there. So how does that affect the analysis here? We have 2021, but we also have 2016.
Well, I think first the 2021 terms shouldn't be viewed in a vacuum apart from 2016. This quote-unquote update was circulated. It's no coincidence very shortly after Cowders struck down the 2016 terms. But even looking at the...
Are there courts that have not struck down the 2016 terms?
Yes, of course, Judge. But looking at the 2016 terms, they are problematic. They created an assembly line of repetitive clicking, where they would have prompts at the top of the page, and then every time you were allowed to go forward, an arrow would turn from gray to black, telling you to go ahead. Then on the very last page of that process, it said at the top, what's your name? And if you entered your name, then that arrow would turn from gray to black, prompting you to go forward.
So if you say you don't look at them without considering the other agreement, the 2021 is a click wrap agreement. You have to affirmatively act. So is she bound by the terms of that agreement?
No, Judge. So looking at the 2021...
Why is she not bound when she clicks? She has to do something.
Sure. So the test that all of the courts have applied, or at least with some consensus, is first, is there reasonable notice? And second, is there a manifestation of acceptance? Whether there is a box to click goes to the action you need to manifest acceptance, but it doesn't go to reasonable notice. What this case is about is what do you need to do to have reasonable notice?
Are there any cases, setting aside the question of pending lawsuits, right? Are there any cases that have found that the 2021 click-through is not sufficient for contract formation purposes?
There have been a handful of very low court cases around the country, but this is something that is very recent. And this is the first court other than the Massachusetts Supreme Court.
I'm sorry, what's very recent? Click wrap or the 2021 agreement?
The 2021 terms have been subject to a lot of different action across
I thought
the
the
country.
Massachusetts case, but correct me if I'm wrong, pertained to either the identical or an equivalent of the 2016 agreement, not the 2021 agreement. Am I wrong about that?
Cowders is 2016, and then the Good case, which is more recent and is in the supplemental letter briefing, that goes to 2021. And certainly as to Good, we think that the dissent is more persuasive in its analysis.
So is there any way, I'm over here, is there any way, in your view, that they could have written this update that would have, if she had clicked it through, would have resulted in both reasonable notice and an assent?
Well, I think it's important to pull apart the thread of arbitration in general and retroactive arbitration to a represented litigant. Mm-hmm. For arbitration in general, reasonable notice would have said something about how this contains an arbitration clause, it may affect your right to trial by jury. Okay. For a represented litigant, describing it as an update that would go into effect at a future time, no reasonable person encountering that language would have understood it to apply retroactively.
So would they have had to include something in, I think it's section 2 on the arbitration agreement language in the terms that of how a pending lawsuit would be treated given this term?
Putting aside the no contact issues, I think it's problematic in general.
Yes, put that aside.
I think it's problematic in general to call it an update, but putting that aside, yes, there would have to be something explicit.
So your argument is not that notice itself was not sufficient notice in this particular case because she had pending legislation was insufficient?
I don't think that we need to get to the question of whether notice was sufficient for a general arbitration clause here, say for a new user, but certainly somebody, and what makes this case different from any that my colleagues cite in their brief, is that it's somebody who was a represented party with a pending lawsuit who was already in litigation, and everything about these terms, from the notice to even once you get through the hyperlink.
So do you agree, though, that simply saying, I didn't read it, doesn't get you off the hook of being bound?
Sure. So we have no quarrel with the idea that there is a duty to read a contract. That is a valid concept in the law. The real question here is whether there is any stopping point on the duty to read when you get to the outer boundaries of it.
But if you are asking us to focus specifically on the issue here, which I take it from what you just said, is that there was a pending lawsuit, and you're saying that differentiates it from the more generic contract formation question. Why doesn't that issue about the pending lawsuit go to the question of unconscionability as opposed to the standard for contract formation?
Sure. So what I'd go to on that is the concepts expressed both in the restatement on contracts, but also the restatement on consumer contracts, which since our supplemental letter briefs has been finalized and published, and also just to the concept of inquiry notice as a whole. And what all of those say is that when you are dealing with standardized contracts, one where consumers we know are highly unlikely to read and are very likely unable to understand, that for terms that are beyond the realm of reasonable expectations for the transaction, that those terms require notice.
So you'd have us pull out specific terms with respect to the contract formation test and suggest that some heightened standard of notice applies?
Well, that's what the restatement does, though it's not a heightened standard. It's just if you're putting something in your terms that materially exceed the realm of reasonable expectations for this sort of transaction.
So why isn't the description that's set forth in the terms for 2021 sufficient to do that? What more would you require them to say for it to constitute reasonable notice in your view?
Well, this one's actively misleading because they say it's an update, that it's going into effect at a future time. Even if you get past the hyperlink, it says that it affects how cases can be brought. That further signifies that it is prospective, not retroactive. And all of those
I thought there was some language which indicated it applied to existing disputes, but maybe I
I mean, if
misread
there
that.
is some language, at best what you have is somebody who is very sophisticated, who knows what they're doing, and has designed a misleading and unclear process. And no layperson represented by counsel in a pending lawsuit thinks that a generally applicable or allegedly generally applicable update sent to them while they're trying to hail a taxi is going to take their pending lawsuit out of the court. It flouts those expectations.
Could we just go back to reasonable expectations for 1 second? And I'm just curious, what is your definition of a reasonable expectation with respect to this kind of provision? Because my understanding from the commentary to the restatement is that it has to really be, I think the word they use is bizarre or oppressive. And this pending litigation term, it's damaging to your client, but I don't know that it would be considered bizarre or oppressive even.
I think that the commentaries go a little beyond that, and also the consumer contracts restatement does as well. But reasonable expectations goes to what anybody would expect when entering a transaction, and it is certainly oppressive to tell a litigant who already has elected a trial by jury that we are going to take away that right where we approached you outside the presence of your counsel, and that you have unwittingly agreed to effect your pending case without the chance to talk to your lawyer.
And that, to just echo a question that I think you already got, that strikes at the heart of the creation of the agreement itself?
Sure, because it goes to inquiry notice. Everybody agrees that what we're talking about here is inquiry notice. What we say is that inquiry notice means what are you expected to inquire after? Uber's answer to that is we can put anything behind a hyperlink, and it's your responsibility to click the hyperlink and ferret out whatever we have put in it. The burden shouldn't rest.
Well, in this case, though, the email that went out prior to the click wrap that comes through on the app did mention that this is going to impact or it says that there are going to be changes to the arbitration agreement. So there is some amount of notice. We're just quibbling over how specific that paragraph needed to be, aren't we?
Well, I read that paragraph almost as consciousness of guilt, because they make the vaguest, most anodyne possible reference to changes or updates to the arbitration clause that will go into effect in the future. They could easily have said, if you have a pending lawsuit, this arbitration clause will take it out of the courts. They didn't do that, and it's fair to wonder, why weren't they explicit?
And if they did that, from your perspective, you wouldn't be here, correct?
Well,
If they
putting aside
did
the no
that and
contact
she
issue.
clicked I consent, your position is, well, that looks like assent. That looks like it's enough notice. She's clicked it, it's assent.
On the question of contract formation, yes, if there is notice of a provision that's beyond expectations.
Yes, yes.
Then sure, like, if they know what they're doing and they know what they're entering into, then that forms a contract.
Is it
But
then
wouldn't-
unconscionable?
Then we would get to unconscionability, but at least there's contract formation in the first
Yes,
instance.
But why
Okay.
would Uber ever put that notice in if their view is the 2016 agreement's effective? Because then they're basically admitting that it wasn't effective to already remove your case from.
I would say, well, they could have used may, but it's also a predicament of Uber's creation, because they played fast and loose in 2016 and tried to get people through an assembly line without knowing they were entering into a very, very consequential clause.
Why isn't she bound with, by the fact that she, after they sought the mandatory arbitration, she continued to ride Uber taxis? Why is she bound by that? Her conduct, why is that?
So I think that goes to their citation to the Second Circuit's non-precedential decision in Nicosia. And it said this isn't supposed to be precedent. But that case, Amazon actually told its users, by buying a product on our website, you agree to be bound by our terms. That's not what we have factually in this case. What we have factually in this case, putting aside the notice, Uber was very explicit about what you have to do to manifest assent. It said, check a box and click confirm. They never said to Emily Wu during the nearly 2-year pendency of her motion as to these terms, and by the way, forget what we already said about checking a box. If you keep using our taxis, that will be another way you can manifest assent to these terms. She had every right to believe, while the validity of those terms was being litigated, that whatever pre-existing terms
But
they had
why-
in their relationship controlled. I'm
Why
sorry, Dr.
isn't
Chapman.
she not expected to talk to her attorney about the fact that she's litigating against a party?
Well, the no-contact rule, putting aside expectations. the
And what
yeah.
should she do? What should she do with respect to future use?
Well, with regard to the no-contact rule, the no-contact rule contemplates that there will be ongoing, potentially neutral contacts between litigants. So she was allowed to reach out to Uber and try to get a taxi, and there were.
And so their non-lawyers could send notices if you're using our services. Here are the rules.
Well, the no-contact rule also contemplates that, and a lawyer can't outsource their ethical obligations to support staff. I can't tell my paralegal, I want to make contact with a represented party.
But how do we
send out
know a
this letter.
lawyer was involved with respect to the update of the agreement?
Well, if there's any ambiguity about this, we had asked for a hearing, and there should be one. But all we have is them hiding behind the affidavit of a paralegal who lives halfway across the country from where the terms were drafted.
Well, where is the evidence that an actual lawyer reached out to her?
Well, the evidence about, all we have to do is look at the terms. They never denied that a lawyer drafted the terms, and no one other than a lawyer could write a legal document as detailed and intricate and conceptually
So
complex
if a
as these
lawyer
terms.
writes it, then a lawyer is presumed to have sent it, or even if someone else sends it on behalf of the company itself, it's deemed to be an act of a lawyer? Is that
Well,
what you're
that's what the
saying?
no-contact rule says. It says that a lawyer can counsel a client about how to make contact with represented parties, but they have to give notice to opposing counsel.
Well, let's
Counsel, was
suppose
this
that
the-
there was an ethical violation here. Isn't what you're asking for, it's basically case ending, the sanctions would just end this case, and isn't that a bit draconian and move much further away from what we usually do in these circumstances?
Well, what we say in our brief is we are more than accepting of the concept that an appropriate sanction would be that they shouldn't be allowed to enforce the arbitration clause. But it's clear that there shouldn't have been contact with a represented party here. It concerned the representation. They knew that she was represented. They knew they were reaching out systematically to represented parties. And at a minimum, they shouldn't be able to enforce the
So if
improper
you-
benefit of that bargain.
If you're willing to accept the possibility that they shouldn't be allowed to enforce the arbitration clause, doesn't that really just go back to the unconscionability issue? And shouldn't that, and because you do have a delegation clause in this agreement, which is not the subject of a dispute, as I understand it, you've agreed to give that question to an arbitrator.
I don't think so, Your Honor. First, no contact is separate from unconscionability. No contact is a boundary that's part of the adversarial process and says you cannot reach out to a represented party who is represented by counsel to try to get something of
Yes,
value.
counsel, but we're talking about the remedy you asked for. And originally, as we heard, the remedy that you asked for was striking of the answer and sanctions, monetary sanctions. But you very graciously conceded that you would also take non-enforcement of the arbitration provision. That's the part, to me, that seems can only go to the unconscionable way in which the arbitration agreement was secured. And that's for the arbitrator.
Well, we cite a number of cases in our brief about inherent authority of courts. Public Justice, as amicus, cites a case Billingsley that also talks about other cases where courts exercised inherent authority not to enforce arbitration clauses. And on the delegation issue, we did validly challenge the delegation clause. Our language in our brief is almost identical to what the Supreme Court found valid in Coinbase in footnote 2, literally almost word for word, verbatim identical. And Uber also didn't even contend in the court below that we had failed to raise some sort of delegation issue. They just said that we hadn't shown that either of them were unconscionable, and that itself should be a waiver of the argument.
Quick factual question. Is this the same account she used to order the car that was involved in the accident?
Which account, Your Honor?
Uber account. Is it the same Uber account?
Yeah, she didn't open a second account, Your Honor.
Thank you.
Thank
I
you.
see my red light is on. Thank you.
May it please the court, I'm Michael Houston of Perkins Coie on behalf of the respondents. Courts in this state and around the country from California to Massachusetts have repeatedly recognized that Uber's 2021 ClickWrap agreement forms an enforceable contract under basic principles of contract law. That's because the ClickWrap ensures that a user gives an unambiguous manifestation of assent to the contract terms and the clear and simple interface.
Have they considered its application to someone who has a pending lawsuit?
So I don't think that specific question has come up.
So isn't that really what it turns on?
Yes, I think so, Your Honor, but that just gets to the fundamental point.
Okay.
The-
But where, make believe for one moment, I'm not a judge, I'm not a lawyer, haven't had all that legal training. I just need this cab to get somewhere. And I open it up, let's say I click all the way through and I spend the time to read section 2. What would alert me that that case I filed months ago is now not going to be resolved in a court of law, but must be sent to mandatory arbitration?
Sure, so I think 2 points about that, Your
Yes.
Honor. The first is that, of course, you already knew in the hypothetical that you had agreed long before the accident, long before this ClickWrap, to another contract with
Yeah,
the
but
exact
that's not
same-
what you relied on, so let's just stick with 2021.
Sure. So I would direct the court to page 118
Okay.
of the record. This is the contract terms.
Yeah.
We're in, the very first page of the terms says, be aware, this is you're forming a contract. Take the time to read this. It creates an important decision.
Right.
So I think right away we're alerting the user, this is a serious thing that should be taken seriously. If you want to know about the arbitration provision, how disputes can be brought between you and Uber, go to section 2. Right there in section 2, it's going to say you and Uber agree that any dispute, claim, or controversy in any way arising from your use of the services,
Yes.
whether it arose before or after you accepted these terms,
Right.
must be decided by an arbitrator.
Again, how would that tell a lay person, that having already incurred the kind of event that created an injury, that they then are filing a personal injury lawsuit on, and they have actually made their choice, that now they are going to have to take, they're going to have to take some action and proceed in a different manner from the choice that they made, which is, I made a choice to go to court. And if I check this little box, I'm going to have to forfeit that.
Sure. So the answer, Your Honor, is that regular people understand what the phrase before or after means. This isn't written in...
Well, no, that one would read that, I think, without legal training, to mean occurrences of the past, occurrences for the future, but not necessarily an occurrence that now I've already chosen to file a lawsuit on, and I have done that.
So respectfully, Your Honor, I think I just disagree about what a reasonable
Well,
person
we may.
would-
I don't know who gets the better end of that, but yeah.
Sure. So I mean, I guess what I would urge the court to take a look at the language on page 118, because I think what you'll see is we're talking about any. First of all, we're using the broad phrase any. Any means any, as the Supreme Court of the United States has repeatedly instructed. But what I think you're looking at here is
If
any.
we disagreed with you, doesn't this mean you just add one little sentence?
So-
This includes pending litigation?
Your Honor,
That's
I-
all it would mean,
So,
correct?
no, I mean, Your Honor, if
You wouldn't do that if we disagreed with you?
Uber strives to have valid, agreements, we would respond to the court's decisions, obviously.
idea.
I think the key point, though, is you can always demand one more sentence. Every plaintiff will come to court, no matter what you say in this case about, well, we needed just one more sentence, the plaintiffs in the next case will say, well, we needed just one more sentence for our lawsuit.
No, but we're talking about this lawsuit, and we're talking about the fact that it was a pending lawsuit. I'm struck. I've never come across, and it just may be that I've never come across it, maybe others have, of a situation where you have someone who has filed a lawsuit, they have record representation by a lawyer, and now another lawyer wants them to proceed outside of that lawsuit, to go into binding arbitration by the fact that they signed some other contract without the benefit of counsel that never refers to that particular lawsuit. Usually if you want, wouldn't this be something you come in and negotiate? And say, look, would your client consider the following? Let's resolve this in arbitration. It'll be better for your client and mine.
So, Your Honor, I think I have to take issue with the premise of the question because, as we've already discussed earlier this afternoon, it is simply not the case that this term was added to this agreement for purposes of Ms. Wu's lawsuit, for purposes of this agreement.
That wasn't asking anything like that. I actually understand your argument. I think it's a very compelling one, that if we just carve out pending lawsuits, this gives quite robust notice. I think it's a very compelling argument. The issue is about someone who is in litigation and having a lawyer depending on this little click wrap in that case.
How hard practically would it have been for Uber to identify the set of people who had pending lawsuits and treat them differently?
Sure, Your Honor. So I think with regard to this case specifically, it's important to understand that the answer.
No, I'm asking not about this case specifically. You can get to that in a second, but generally, I assume people have sued Uber, and there's some number of pending lawsuits, and you have a legal department, and they have to keep track of that.
Sure. So there's thousands of lawsuits that get filed that touch Uber in some way.
Do you have a process in place for identifying those individuals, though, and shielding them from communications like this, which send out updated terms of service?
I don't think the record doesn't reflect that, Judge Halligan, but I think I do think it's important to understand that this term, and specifically the before and after clause that gives rise to, in the 2021 terms, that makes the contract enforceable as to Ms. Wu, even though she'd already filed her lawsuit, that wasn't added in 2021. It was
I understand,
added in
but
2016.
it sounds to me, just so I'm clear, that you can't tell us whether your client has in place any mechanism for identifying individuals who are plaintiffs in a pending lawsuit and taking their name off of whatever list there is that goes out with respect to updated terms of service, or even perhaps telling them that they can't procure services or something like that. So you don't know whether you have that
The
mechanism.
record does not reflect anything about that.
Well, counsel, you have done that for class action litigants. Uber is able to screen for class action litigants, right? They've been directed to do that.
So litigators at Uber who are responsible for the handling of those cases do have a process, obviously, to comply with Federal Rule of Civil Procedure 23D, which affects our ability to contact them when they are absent class members. That's, of course, for the purpose that if you're an absent class member, you may not know that you have a lawsuit.
My only point is it doesn't seem like it would be that far a leap to identify those other people who have their own individual, say, personal injury lawsuit, and they're represented.
So,
I mean, I get that the record doesn't reflect whether the technological capability is there, but it seems like something very much like it exists in other contexts.
So, Your Honor, I think what we're striving to do in this line of inquiry is come up with a process to mitigate the apparent unfairness of a situation where somebody files a lawsuit and then for the first time agrees to an arbitration clause that takes that case out of this court. That's not what happened in this case for two reasons.
But yeah, we all understand that there's an issue involving how notice was served in this case that you can make an argument that you weren't aware, but there are other litigants who as Chief Judge Wilson said, there are other litigants surely who had active suits against Uber who could theoretically have been screened out of this update.
So respectfully, Your Honor, I'm not sure that that's actually correct. I mean, this provision, the before or after clause, was added to Uber's terms of use in 2016, 4 years before.
However, in our modern society, people have to use these services, whether if they become a part of their everyday life, whether it's Disney Channel or others that have these arbitration agreements, Uber, if you live in New York City as opposed to upstate New York, you may be more dependent upon. What my colleagues are asking you is, you have this great power here, and arguably some might think it's unfair to the consumer. This broad sweeping, that even though I filed a lawsuit, it applies to everybody, and there's a concern. It's not a defense, you didn't read it, but it's packed with all of this information in it. Why is it unfair to Uber to excise out people with pending lawsuits due to the fact that we have software that can search all kinds of things?
So I completely understand the question, Your Honor. I think what you're asking is, why is this particular term fair as, and enforceable in Ms. Wu's case specifically? The first and most important answer that I have to give is that that question has expressly been delegated to the arbitrator for resolution. You can see this at page 119 of the record.
So your argument is these agreements are fine, and as to her, if there is an issue as it being overreaching, unfair, it is something, because of the delegation clause, she gets to have it answered, but she gets to have it answered there, just not in a court.
That's exactly right, Your Honor. That's critically important. The Federal Arbitration Act, as interpreted by the Supreme Court of the United States in cases like Renner Center.
Why didn't you raise that issue previously?
I'm sorry, Your Honor.
Why didn't you raise that issue previously?
We absolutely did, Your Honor, respectfully. I mean, I think this is, it's
Where
all.
would I find that in the record?
Sure, it's all over our opposition to the plaintiff moved to stay the arbitration. In response, we cross-moved to compel arbitration and oppose that. The very first, paragraph, I think, first page of our brief, and I think it's at record 191, if I'm not mistaken. I'll have it for you exactly in a moment. But we certainly argued at length that this question, any question about the enforceability of the terms, the unconscionability of the term in plaintiff's case specifically, have been delegated to the arbitrator for resolution.
Counsel, even if we agree with that proposition, this body, as the stewards of the ethical standards of our profession, I would think has an interest in saying, we don't want attorneys to obtain arbitration clause. Whether they're delegable to the arbitrator or resolvable in a court is another issue under the contract, but we don't want attorneys obtaining these kinds of favorable terms through unethical conduct. And the question that I was trying to ask previously is, it seems to me it would have been pretty easy to avoid this allegedly unethical conduct by screening out those people. So why wouldn't you do
Counsel,
that?
on that case, let me ask you something on a follow-up on the screening. If I'm riding in an Uber, I wasn't the one that ordered it, I'm with the person that ordered it. Get in an accident, I sue Uber. Am I bound by the arbitration agreement that the person who ordered the Uber signed?
Multiple courts have found that you probably are, because you're a intended third-party beneficiary of that contract, and the contract specifically covers third-party beneficiaries. Of course, it's not presented for this case for decision. If I could return to Your Honor's question just about.
But just to go to screening, that would mean that, as I understand it, that Uber lawyers then would have to determine passengers and what accounts they had so that they didn't violate this no contact rule.
So I agree with that, Your Honor. I think that's yet one more problem with the suggestion about, well, it would have been so easy to carve that out. Again, even if we could carve that out, even if we could identify exactly what is the status of every person's assent at any given time and track that against whatever litigation filings they may have, and we're talking about thousands of cases going on at any given time all across the country, even if we had the technological capability to do it, it's not going to do anything to help Ms. Wu because she agreed to arbitration 4 years before
Let me
her
just
accident.
understand, we've gotten the four-year point several times now. I think we get that one. Let me ask you something about Judge Garcia's question. So suppose the passenger in his hypothetical had an Uber account, gets a click wrap, and rejects the new terms, right?
Yes, sir.
Still bound.
No, Your Honor. I mean, at that point, they won't.
No,
well,
if they're a passenger, they're still bound as a third-party beneficiary of the person they're riding with.
I'm sorry. So maybe, but it would depend on, what is the status of that person's account, and are they is there another method?
Oh, okay. So if they have no Uber account, they're bound. If they have an Uber account, but they reject the click wrap and then no longer have an account because they rejected the click wrap, then they're not bound.
So, appreciating that it's not the question before the court, like if there were an instance.
That's why it's hypothetical.
Sure. If there were an instance where a person rejected the click wrap, they're not going, they haven't manifested their assent unless they use the services.
But they're a passenger.
Sure. So in that instance, they're an intended third-party beneficiary of another person's
And so
contract.
even though they themselves have rejected the idea that they're going to be forced into arbitration, they're going to be forced into arbitration.
So but Your Honor, that happens all the time. You can form a contract. You can be a third-party beneficiary of somebody else's
Would the
contract.
flip also happen? Let's say the passenger has an Uber account and they've accepted the terms, but the person who ordered the car rejected them. Then would the person in the car be bound by the own acceptance of the arbitration agreement?
Respectfully, I don't think the situation would arise because if you don't accept the
can't order
terms,
it.
you won't have the means to access Uber's services. That's actually, I think, a virtue of this, right? It calls the user's attention specifically that, look, if you want to use our services, you have got to agree to these terms.
Can I ask you about the 2016 agreement? Is it indistinguishable from the agreement at issue in Cotters?
No, it is not indistinguishable. It is distinguishable,
In
Judge.
what respect?
Sure, Judge Halligan. So I would urge the court to take a look at the record on page, this is the interface is in the record at 289. So in Cotters and in the other cases that my friend refers to, that he says invalidated the 2016 agreement, that was a different user interface. What the courts found problematic about that interface in Cotters was that the terms of use hyperlink was on a screen where you were also asked to provide payment information. So they said.
So I'm looking at 289.
Sure.
How is it different exactly?
Sure. Because in Cotters, what you see on 289 is not what you would have seen in
Yes.
Cotters. In Cotters, there was a screen that was about enter your credit card information, and that's the feature that the court in Cotters said made it problematic. Because they said the user is focused on entering her credit card, she doesn't know that she's being asked to agree to terms and conditions. Well, in response, the interface here is very different from 2016 because, of course, it says, I confirm that I have read and agreed to the terms and conditions and the privacy policy, and you have to hit that arrow to confirm that agreement.
So it is distinguishable, though, in that
Yes.
you're not, from the 2021 agreement, in that you're not clicking the specific box.
So that's also true. 2021 is a little bit of a different agreement. The Massachusetts Supreme Judicial Court's decision.
Clearer, one would say. Is that fair? I understand you say 2016 is also clear enough.
Yes, I agree with that the 2021 is clearer in some respects, the key ones being that you have to give your assent twice. You have to both put a check box, click box next to, check a box that says, I have read and agreed to the terms of use. Then you have to hit a separate confirm button.
Yes.
So I agree that the 2021 is even more clear. We went above and beyond. I still think that the agreement in 2016 is fully enforceable because this key language here, by continuing, I confirm that I have read and agree, that was
So
not
why didn't you rely on it?
I'm sorry?
Why didn't you rely on it?
We did, Your Honor, respectfully. I just don't think that this is, I'm not sure why my friend says we didn't. Again, if Your Honor looks at our response in opposition to the motion to stay the arbitration in the Supreme Court, we again referred to the 2016 interface by which the user confirmed her agreement, and the fact that the terms of use are exactly the same, including the before and after clause, which I think, again, just reinforces that was not a provision that was somehow added only in 2021, and like Ms. Wu became bound by that for the very first time in 2021.
Is that the first time it was raised?
No.
It's not raised in your initial
The
papers?
26
Just to be clear, the 2016, your reliance on the 2016.
We invoked the 2016 terms
Right, and you said in response?
in response to the plaintiff's motion to stay the arbitration.
Right.
Sure. Now,
In your initial papers seeking the stay for mandatory
so Your Honor,
arbitration, did you refer to the 2016?
The plaintiff made the first motion. The plaintiff filed in the Supreme Court a motion to stay the arbitration.
Mm-hmm.
We responded and said, we think the 2021 click wrap is enforceable, but also, by the way, you signed up for arbitration in 2016.
But I'm sorry, their motion is filed in response to your only asserting the 2021, or have I misunderstood what
Okay,
went on here?
I understand, Your Honor. So it is true that in our initial demand for arbitration, which was not a court filing, we sent it to the
Yes,
plaintiff, we
yes.
said, you are bound by the 2021 terms. Of course, it made sense to do that. That was the operative contract. That was the most recent contract. The appellate division's decision in Mejia addresses this issue and cites multiple cases for the proposition that a party's failure to mention every sequential contract that might be in existence does not mean we're waiving our reliance on those other ones. We cite the one that's, the most operative. That creates a binding contract. We're not saying, and nothing else does. Plaintiffs certainly had a fair opportunity to brief to the Supreme Court the validity of the 2016 terms. And the last
But if let me just say this, if the dispositive deficiency, let me put it that way, of 2021 is the failure to somehow refer specifically to pending actions, whatever language might have been used for that, you would agree that that would be the same problem in 2016?
No, because it wouldn't.
Neither one refers to pending actions, correct?
Yes, that is correct, Your Honor. Okay. No, I'm sorry. They both have the same clause. They have the same before and after clause in 2016 and 2021. Yes. So I guess if Your Honor, but of course in 2016, there is no pending litigation, right? I mean, that's the whole point, is that when she signed up for arbitration in 2016,
Yes, I know it's
years
applied to her, but
before
I'm
the
talking
accident.
about that carve-out.
Yes.
It's not found in either one. But of course, you are correct. In 2016, at the time, she was not in litigation.
And the last thing I want to say about 2016 is just that this language, I confirm I have read and agreed to the terms and conditions. I think that's exactly the kind of solemn, what the Massachusetts Supreme Judicial Court called solemn I agree language that alerts the user that they are forming a contract. It's
Sorry, can I just ask you before your light, well, now it goes on, but to briefly address the Coinbase Rent-A-Center point?
Sure, Your Honor, absolutely. So I think I agree with Your Honor's suggestion to my friend that the heart of this case is really not about whether there was a valid contract form. It's almost all but common ground that the 2021 click wrap forms a contract. The question is whether one provision of that contract, the arbitration agreement, is enforceable because of Ms. Wu's specific circumstances. That's an argument that the contract term is unenforceable or maybe unconscionable. That argument was expressly delegated by the parties to an arbitrator, and that separate arbitration provision, Rent-A-Center tells us, has to be enforced by this court.
And what about Coinbase footnote 2, which I think is what your adversary is relying on?
So I think it's I don't mean to be pedantic, I think it's the star footnote in Coinbase, Your Honor, respectfully,
whichever footnote.
but the relevant footnote in Coinbase says, and first of all, I think it's dicta in Coinbase, but because that wasn't what the court was talking about, but what the Supreme Court is saying is, in response to the delegation provision specifically, the plaintiff in Coinbase said what that plaintiff thought was wrong with the delegation provision. We don't have anything like that here.
So you're saying nothing that specifically is targeted at the delegation provision as opposed to the agreement as a whole?
That's exactly right, Your Honor. And that matters. That's critical because that word, a specific challenge to the delegation provision, that's what the Supreme Court of the United States said the Federal Arbitration Act demands, and if there's any way that the delegation provision won't be enforced. And you will find nothing in my friend's papers in the Supreme Court where he said what is unconscionable or unenforceable about allowing an arbitrator to resolve this question. So for that reason, all of the questions in this case that go to enforceability or alleged unconscionability or alleged unfairness of the term in this particular case, Ms. Wu is going to have an opportunity to make those arguments, but she has to make them to the arbitrator.
Thank you.
Thank you.
So if I might, I want to start on the no contact rule and to get to Judge Garcia's hypothetical.
Why don't you instead pick up on delegation?
Sure, Your Honor.
And what did she specifically assert that which would allow her
So
to
the
get what you're
Coinbase,
asking?
my apologies, star footnote says that using the objection to the word arbitrability was sufficient to challenge the delegation clause. Our papers below, it's in the record at 361 and 362, also said in response to Uber's argument about arbitrability that no issue was properly delegated to the arbitrator, so that is identical. Getting to no contact, numerous courts have held across the country that you can't use mass communications to affect contact with represented parties. Judge Garcia, you asked about the passenger. There wouldn't be contact with the passenger there because the contact would be with the person who hailed the cab. So ipso facto, there wouldn't be a breach of
The
the contact
passenger
obligation.
has their own account,
Well,
right?
but if the question is, what are you allowed to do if you contact a represented party?
Right.
In your version,
The
they're not
passenger
contacting a
sues,
represented party.
Passenger's represented. I sue. Let's say it's Joe Smith. Joe Smith sues. He goes with Jones's account, though. He's a passenger in the car they hail on the app. And now Mr. Smith orders an Uber on his own account. That's my hypothetical.
I don't know if I'm exactly following it, but if I understand it, it's person A has the lawsuit and person B hails the cab?
Yes.
Well, there's no contact there with person A, so the
But
attorney
let's say
isn't-
they get, person A has their own account.
Right.
And later, the 2021 terms come around and person A clicks, sure. Why isn't that contact with a represented party?
Well, if they're contacting the person with the lawsuit for the purpose of affecting the lawsuit, then that is
But
contact.
they're contacting them exactly the same way. Let's put the rhetoric aside. They're
Sure.
contacting them exactly the same way they contacted plaintiff here. New terms, go out to everyone, passenger A has their own account, and they click yes on the terms.
Well, what they're doing there, even if it's the same email, there's a specific term of the terms of use that is intended to affect represented parties. The reason we are here is because they admit they drafted a clause of their terms of use to try to take pending cases out of the courts.
But to go back to my hypothetical, A is represented. They just didn't hail the cab, the car, the original incident. Would that also be contact for you, since now they're using their own account?
If they're
and
trying to affect person B's lawsuit, then it wouldn't concern the subject of the representation.
But in
but
this,
I'm sorry.
what about the fact that does it make a difference if it's the person seeking a ride that causes the click to come up as to, well, if you want the ride, now you have to review the updated terms? Is that still a lawyer contacting a represented party?
If the lawyer drafted the terms of use with the intention of affecting the lawsuit, then.
So
Rule
even though the
4.2 would say
person
that.
sought contact with Uber, that's still on
Yeah, and Rule
Uber?
4.2 specifically contemplates that. You're allowed to have neutral contacts with a litigant. What you can't do is weaponize it to affect a case, and the commentaries are pretty clear on that. The other thing that I would say, we talked before about how.
I'm sorry, counsel, before you get to
Yes,
that
Judge.
other thing, I want to get back to the actual terms of use in the agreement, because there was a question to your adversary about what a normal person would understand, a non-lawyer would understand if they took the time to really read the terms of use. Do you agree with your adversary that, if you really spent time reading the terms, that the effect of that language is to give up your right to a trial in an already pending action?
I think every part of the process was intended to be set up so a layperson could never get there because they say it's an update.
Leaving
Even so-
aside
Yeah.
notice and inquiry notice, just the language itself. If you read it, do you come to the understanding, after much thoughtful, analysis, that you're giving up your right to a pending lawsuit?
Even with legal training, it's at best ambiguous, and that's me with a law degree. We talked about burdens of carving out represented parties. It would have been extremely easy to do so.
Why is that? I'm looking at the language, and, counsel spent a lot of time talking about before or after and how that's typical language. The language that comes before that is whether the dispute, claim, or controversy occurred or accrued before or after the date you agreed to the terms. So to me, it doesn't even mention the accident. It's not like a person would say, this doesn't apply to accidents that happened before the date of the agreement. It actually says claims, controversies, and disputes. That seems susceptible to only one interpretation if you think about it.
Well, I think it's a well-settled principle of New York law that if something is beyond the realm of expectations for the transaction, that the contract isn't construed that way. It doesn't say lawsuits.
Why is that beyond the realm of expectation if that's what it says?
Well, because again, you have a represented party with a pending lawsuit, and it doesn't specifically refer to lawsuits. It's an update. Just as to carve-outs, I guess I've tried a couple of
So
times.
claims, controversies, and disputes, that's not good enough because it doesn't say lawsuits?
In context of inquiry notice for a layperson, certainly not, and for a lawyer, arguably not. And as to carving out people who are represented and have lawsuits, all you had to do was 6 words. This does not affect pending lawsuits. And then no term they had here would have infringed on any pending lawsuit. It was a conscious choice by Uber that they wanted to go behind the backs of lawyers for represented parties. That clearly violates the no contact rule. And by its holding here, the court should affirm the integrity of the judicial process and not allow corporations with impunity to poach pending cases from the court without notice to counsel.
Thank you.
Thank you.